Hello, everyone. I have the pleasure of introducing a new series of events here at DCLI. And I'm here with Professor Wes Oliver, the Director of the Criminal Justice Program and Professor of Law at the Duquesne Klein School of Law. His teaching and scholarship have examined numerous aspects of criminal law, criminal procedure, and evidence. His multiple books and journal publications have addressed issues of search and seizure, interrogations, material witness detentions, wiretapping, plea bargaining, the doctrine of chances, approaches to defining terms in criminal statutes, and the history of policing. In 2018, Professor Oliver published The Prohibition Era and Policing, a Legacy of Misregulation, with the prestigious Vanderbilt University Press. And it demonstrates how America's noble experiment played a pivotal role in creating many of the judicially created limits on modern police. And today I have the pleasure of talking to Wes. I hope I'm not presumptuous. Okay. I am Dana Neacsu. I'm the director of DCLI, and I prefer to go by Dana. So here we have the first questions. They are adapted from the famous or infamous Marcel Proust questionnaire. And for those of you who are not familiar with them, that's okay, because they are much changed for today's event. So I'm going to ask Wes, how would you like to introduce yourself after you heard me introducing you?
Yeah, so I think sort of very basically, I mean, I teach here at Duquesne, and I teach evidence, criminal procedure, criminal law, and coding for lawyers, which is new. And I've sort of, in my entire career, you can either look at it as very broad. I've worked on everything from legal history to strict legal doctrine to now computer science, and looked at all sorts of like quirky things. And my latest piece looks at how Joan of Arc was instrumental, perhaps. We're still digging into this in oddly inspiring what became the Miranda warnings. So that's really that's French history, and we look at how that delves into Russia, et cetera, et cetera. And then I'm working on stuff with computer science, and so we're looking at how you can use artificial intelligence, machine learning, to extract words from legal text. So that's kind of, if you want to say, well, you do a lot of broad stuff, that would be how you'd say that. But most of my stuff has been fairly limited to law and police. So a lot of search and seizure law, a lot of drug interdiction stuff, and then with prohibition, like how we regulated search and seizure. So if you want to tell a broad story, I've done everything from legal history to math. But if you want to tell a narrow story, I'm a person who's primarily focused my efforts on policing.
All right, that means you are very relevant, especially after all the events that happened in the US during and post-COVID. So
Maybe.
Congratulations. And the next question, what inspires you to write?
Well, actually, I'm not sure if anything inspires me to write. I think for me, things inspire me to research, and the writing is just sort of the necessary part of it. One of my professors in college talked about how that he was actually, I had a legal history class in undergrad, brilliant guy, Charles McCurdy, and we did a kind of senior thesis, and he said, right now you're in the fun part when you're out discovering all this information, when you're combing through the ancient newspapers and you're finding these cool things. The worst of it's going to be when you're actually sitting down hammering this thing out. And his career was actually quite reflective of it. He was this brilliant guy who published one book in his life, and that was well after I had him as a professor. And when I had him, he'd been in teaching for 16 years. But he did a few articles and stuff, but like he apparently wasn't like a prolific writer. I thought but he was absolutely brilliant, and stuff he did write was amazing. But I think he's absolutely right to say that the fun part is the discovery. The work is in putting that out.
So would you like us to, I don't know, become more involved with your work here at DCLI? I take great pride when you send me now and then a request for something interesting. Why don't I get this book on, I don't know, policing in 16th century France or something like that? Oh, it keeps us on our toes here at DCLI. And I think it broadens our horizon. Everyone here really enjoys, reading extracurricular
Right.
things so we can help our amazing faculty like you.
Thank you.
So we are here to say we are going to do our best to support your research and through that your writing. So the third question is, what are your favorite legal writers?
Yeah, so my favorite legal writers are typically judges. I think Robert Jackson would have to be my absolute favorite legal writer of all time. And I often talk about Robert Jackson in class.
Tell us more.
Yeah, sure. He he wrote the flag salute case. He wrote the Youngstown sheet and tube case about presidential powers. It seemed that whenever Jackson was a really fascinating guy, he died at very young, I think 62, I think. But so he didn't have long on the court. He was a Nuremberg prosecutor. He just a really fascinating guy. But I often talk about him in class because I say, part of getting your ideas accepted, there's almost a poetry to the way that you write and then get your ideas accepted. Jackson's opinions, whether they were dissents or concurrences, quite often went on to become the law. So he would write, I think he was in a concurrence in Youngstown, and he lists like the 3 levels of presidential authority. It's become like the staple of that. The flag salute case, if there's any fixed star in our constitutional constellation that no person shall be bound to. I don't even know what comes after that. What's the most important is what comes after that. But because if there's any fixed star in our constitutional constellation, you're sucked into whatever comes after it. It's like the Declaration of Independence. Jefferson, probably the greatest legal writer of all time. No one knows what the grievances actually were. It's the preamble, right? It's like, he's saying why we're going to tell you why we're pissed off. And he writes it out beautifully. Has anyone ever read past the preamble of the Declaration of Independence? And Jackson had that kind of style, although his rules were actually pretty good as well. They were just legal rules like everyone else created, but he wrote them so beautifully that everyone recited them.
How did you first encounter his writing?
Oh, I think an undergraduate class I had on I think an undergraduate constitutional law class that I had. I first saw it. I said, "Wow, this really is quite incredible." And I noticed how his case really going to become the law. And so do you ever notice glimpses of your own self in people that you've admired? And I think the first and only time I've seen this a couple times, I suppose, when I would write a brief and my opponents would write their response and they would quote me and I wouldn't realize they were quoting me and they'd say my opponent says, and I'd miss that first part and I would read just that part that they had quoted from me. I'm like, well, damn, that's good. And I was like, oh, that's what they're critiquing because they say it's wrong. No, it's 110% correct, and it's beautiful. But I always liked it when I would see my own stuff thrown back at me and I was like, man, whoever crafted that, and that was always kind of nice. But no, I mean that was that's that I'm not that great of a legal writer, but it was nice when I had that feeling. But there are people in practice who are just spectacular at it. There was a guy I worked for in the first year after law school named Lloyd Snook. He does a lot of death penalty litigation. Bruce Ledowitz, who on our faculty who used to do a lot of death penalty litigation, very familiar with this guy. Had a small shop in Charlotte, so not a big firm. And his briefs were, you felt like you were reading Holmes or Jackson. So there are people who do this and do it very well. I don't think the law review format is one that draws out that kind of
words,
beauty and eloquence. Yeah. You find people saying very interesting things, but I almost look at, as a legal scholar, I almost view law review articles as like raw data from which I'm able to cobble together and say, look, people are talking about this, people have made this argument, and this is where I fit in. But I don't ever find myself picking up a law review article for the sake of it. Justice Kennedy in the Obergefell case, that was it's a very emotional issue that he's talking, that when he basically created the constitutional right to same-sex marriage. Kennedy, I never thought was a particularly amazing writer. When he wrote that, friends of mine who got married, who were able to get married because of this, they quote from it at the ceremony. A friend of mine actually presided over a same-sex marriage, and he quoted from that opinion. I think Kennedy knocked it out of the park with that one. So there are people like Jackson who do it all the time, and there are people like Kennedy who occasionally, like, you'll read it, you'll kind of choke up when you read it. So I think those are examples of things I found interesting.
Jeffrey Tobin, the analyst on the CNN, also mentioned exactly as you said that Kennedy's writing in Obergefell was spectacular.
Yeah.
And yes, that's wonderful.
Yeah, when you've written something that becomes part of a wedding vow, you've done pretty well, right? Yeah.
Yes, I think so. I never had any of that feeling reading anything legal. The only author that I felt that spoke to me was Cesare Gomez in a book, I'm not legal book, but very interesting what you're saying.
I think, and it's interesting when people who aren't lawyers write about law. I think they almost have a better ability to write about it. I'm reading a book right now, actually I'm reviewing it for a new kind of, it's not the New York Review of Books, but it's sort of meant to be a competitor to that. It's called The Wiretappers. And it's this book about the history of wiretapping and its regulation in the US. Okay, fine. But it's actually quite compelling. Like, this is really wonderful. And more than once I went back and caught myself like, who is this guy who wrote this book? He's an English professor at Georgetown. And it's all legally quite correct. So he's done a lot of background. As best I can tell, he's not formally trained as a lawyer, but the storytelling is great. Dave McCullough, one of the great historians, had no history degree.
Presidential project, right?
He did Truman, but he also did the Brooklyn Bridge. He did John Adams. He did a variety of things. His first big book was Truman, but that was like later in life for him. He was 59, and that was his first big book.
That's the only one I read.
Oh yeah, and it's great. I'm actually reading it now.
Nice.
But he was trained in English at Yale, and then he did journalism. John Meacham did journalism for a long time, and now he's writing history. I almost think when people come to disciplines like history or law who aren't formally trained in it, I've read some very substantively interesting books in history by people who are trained historians, but often they're very kind of technical. And so though there are definitely exceptions to that, Donald Miller is a great historian who wrote a history of Chicago that reads like something out of the Odyssey. It's phenomenal, really worth reading. But I often think when people come to a subject like law or history, the two that I read the most in, for whom that's not their background, they bring an ability to tell that story because they're not checking off the boxes that the academics in that field will insist upon to publish it. They're just telling the story in a way that's compelling.
Yeah, I totally agree with you. There are two volumes remarkable in their content about the American legal education, the history of the American legal education by Moore Horowitz.
Mm-hmm.
And they're quite remarkable, but I never felt that connection because I think they're too academic.
Mm-hmm.
As you said, they were expected to say something in a particular way, and they did a brilliant job.
Yeah.
But it's very hard to find that emotional connection.
Right.
So
right.
thank you for sharing.
And I think judges to some extent recognize that if it's a high profile case like Obergefell, I think judges who are writing like that recognize they are writing for history. They're writing for the public, that, this is something that will kind of, transcend the law. And I think that changes the way you go about writing something like that.
And they will be remembered by that.
Absolutely.
That's their legacy.
That's right.
Thank you. We are moving forward. So what piece of your scholarship would you like to talk about today?
Sure.
And now that we went back and forth and I didn't bring your book,
That's okay.
because we are going to talk maybe about something that you are.
We can talk about
now.
either thing you want to work on. Want to go? I've written this book on how prohibition, in my view, created all of criminal procedure. A bit of an exaggeration, but more or less. And then of course now I'm working on I'm working with a former student of mine to hopefully build a device that will help police officers determine in their patrol cars whether they have adequate suspicion to continue a stop to investigate the possibility of drug trafficking. So those are the two big things, and we can do either you like.
I would also like to see, where does Joan of Arc come?
Oh yeah, Joan of Arc. So right. So as part of the Prohibition book, I did a little thing on the history of interrogations, and showed how that actually that U.S. search and seizure law changed interrogation law. We came to reconcile the way we regulate both interrogations and search and seizure. It was in the 1930s, the Supreme Court decided that we should regulate interrogations to make sure that torture doesn't occur regardless of whether we torture a false confession. Prior to that, we were only worried about false confessions, however they were obtained. We thought torture might have some role in that. And so looking at all the interrogation stuff, I discovered the origins of Miranda warnings, which I had traced back to the 1790s. I traced it back to the 1796. I found the first example of it. And then there was a Supreme Court case last year. I was asked to do an amicus brief on behalf of a bunch of legal historians. And we found some more cases, thanks to my amazing research assistant, Nichole Singleton, and a British historian named Tim Hitchcock. We found cases that went back to 1749 with Miranda. And so I was in Paris recently, and there was a statue of Joan of Arc, and I said, I didn't know who Joan of Arc was. I've heard of her. I don't know anything about her. I Googled her, and come to find out that she was burned at the stake for heresy and a bunch of things. And when they went back and re-examined, the Vatican created an inquisition to re-examine her trial, they determined that her confession was given, they say, illegally because there wasn't a lawyer present. So I'm currently playing with the idea of whether these Miranda warnings that we can now trace back to 1740 in the Anglo system, whether they have their origins in the French and more generally the ecclesiastical courts, through, did the Joan of Arc experience. It was a church proceeding, as under the auspices of the church that she was burned, and it was under the auspices of the church that her trial was then re-examined in 1456 and determined to be unlawful. Did the Joan of Arc story influence British judges in the 1740s to start giving what would then later be known as the Miranda warnings? That's the story I'm tracing down right now.
I know some of the history, but that happened. Joan of Arc was burned under the British administration.
Mhm.
So it is possible that they felt uncomfortable after supervising that type of trial.
Yes.
I see having direct connection.
And my guess is, if there is an influence, we're still at the early phase, right? How would you show it? What I'm hoping to find is that British magistrates or British lawyers generally were reading the exoneration. Like if we can find some record that British lawyers were reading this 200-page document that was the exoneration of Joan of Arc, which was published. If we can place that in the hands of British lawyers, particularly magistrates, and there was a guy named John Fielding who was a very famous magistrate from this time. He was one of the ones who gave one of these early warnings. If you could find John Fielding's library list and show that the Joan of Arc book was in his possession, that's some evidence that like maybe there was some cross-pollination between the ecclesiastical system and what happened in France under it and what happens under the civil system in England 300 years later.
And I even think that Jeremy Bentham, who was so into criminal justice, and as you know, he created a panopticon for Catherine the Great in Russia, and he always wanted to, you know, review and better the British system. Maybe even his reading list or his collection.
So he would be,
indicative.
he's later, but
Correct.
but what's interesting about Bentham though is, so Bentham did write about these warnings.
He did.
He did, it's interesting you should mention the Russia thing, because if you in the Brothers Karamazov, Dostoevsky talks about how that in the investigation of the one of the brothers who goes on trial, he was twice warned by the interrogator that he has the right to remain silent. And so I've been trying to trace down part of this story. How did this warning travel to Russia? Pretty clearly, I don't think it was under Catherine, because there were judicial reforms under Alexander II in 1654. I'm sorry, 1864, that allowed for the trial by jury. And my guess is, if there were warnings that were in Russia like this that are referenced in the novel, that if the novel is an accurate reflection of Russian law at that point, that those warnings came into place as part of the Alexander II's judicial reforms. But we do know, as you say, that Bentham wrote in his major evidence treatise about these warnings, and that there is a direct link between Bentham and Catherine. Right, absolutely. And for generations then in Russia, people were reading Bentham. But now here's what's interesting about Bentham. Bentham mentions the warnings, but Bentham says they're the law, but they shouldn't be the law.
Oh,
so to the extent,
is very illiberal for him, because he was so. He was quite liberal in my reading of his criminal system.
Maybe. So here's, of course, Bentham is a utilitarian, and the question is, like, do the warnings? Does the benefit of giving the warning outweigh the cost of it? And he actually wrote that the cost of this is that people, these interrogations are essential. This is too much. This is too kind. This is more than needs to be done.
Wow. Mm-hmm. That's a reevaluation of Bentham. I have to.
Well, in this context, right? In this context.
Yes. Because I know that Panopticon looks horrible, but for the circumstances, he promoted this as quite humane. So indeed, we have to always look at circumstances and see why that was given. So, so the Joan of Arc piece would be just a chapter, maybe some extra writing to the past book. How would this?
So yeah, the Joan of Arc piece. Actually, Nichole Singleton, my research assistant, and our current research assistant, and I are now working on this. I was invited to speak at a conference on the history of legal treatises at Yale. And so she and I are going to co-author this piece
in March. I will be there.
Oh, you're writing on it.
I'm writing about legal treatises also.
Well, excellent. We'll both be at Yale. That's wonderful.
We'll be at Yale.
Yeah, that's great.
Wonderful.
Yeah. So we're right. So this is how this came up. She and I both did this. She worked on this brief with me to the Supreme Court, and we found all these. It starts, the earliest treatise reference to these warnings appears to be William Dickerson, who was a magistrate in the 1800s. In 1806, he references it, and then there are all these that kind of trickle out from there. And we thought, well, this will be an interesting. We can. This conference came up. I'm kind of interested in treatises, and so I submitted this proposal. And the big deal for me is for Nichole, is I didn't get a chance to reference her in the brief, because this is an amicus brief to the Supreme Court. It's difficult to kind of find a way nicely to reference your research assistant. But she did an extraordinary amount of work. She found 3 cases that no one knew existed, providing warnings.
With help from DCLI.
Yes, with help from DCLI, of course, absolutely. That no one knew existed prior to the adoption of the Bill of Rights, which is obviously hugely significant for this particular court that's really into originalism. And so I was really hoping there would be some way I could recognize her work. And so, we're going to co-author this piece that we're going to both, she and I are both going to go and speak about at Yale. I think I'll let her just do the talking. I'll hang out in case people have questions for me. we'll both be on the paper. And
I think it will be published.
yes,
Everything that is presented there will make it into some.
they're publishing it in the Law Library Journal.
Oh, okay.
Mhm.
So that's nice.
That is nice.
That is nice.
Yeah, so that's what we're doing.
Our perspective, my co-author and mine, is that treatises, going back to the piece that was published by the Duquesne Law Review, are relevant for what I call their reflective thinking,
Mhm.
and they are nowhere disappearing. And we present some empirical data that are being quoted,
Yeah.
and by cases, by
Yeah.
lawyers in briefs, by faculty members in their writing. So that's our approach.
Very
Nothing
nice.
as sophisticated as
Oh,
yours.
no, not at all. But our angle on this is we haven't finished figuring out the angle yet. But I think where we are is this, that treatise writers in the 1800s had a type of power they don't have today. Because if you look at William Dickerson in 1806, who first writes down the magistrate must provide the warnings, the Miranda-like warnings. 1806, he writes down a treatise. Where did he come up with that? It was in no statute. No judge had said that, but it was the practice, as Nichole helped me find, going back to the 1740s, there were examples of judges doing this. We don't know how many actually existed. We know that in the Old Bailey session papers, we found a few, and that's actually significant because the records of trials weren't very procedure heavy. So we can assume it was more, but we can also be pretty certain it wasn't everybody doing it. So William Dickerson, who was a magistrate himself, said that the magistrate must provide these warnings. He's now creating law.
This is marvelous. I can suggest two things. One is the connection with the continent where the doctrine is law.
Oh, right. Yes.
So you can have that. But also, as you said, treatises in our own research, Paul, and my research. Indeed, they came with that strength offered by Blackstone's commentaries. So although they differentiated into various areas of law, they had that punchline. This is what the man said, Blackstone.
Yes.
We are saying.
Yes.
How he said it.
Right. If Blackstone said it, it was the law.
Exactly.
Where did Blackstone get it? Sometimes Blackstone was making it up.
Absolutely.
Right. Dickinson wasn't making it up. People were doing it. He was making it part. Magistrates must. Magistrates do, not magistrates must. So that one little change, if people were reading this assuming that was the law, of course, then that becomes codified. And then part of the story we're going to tell is how did counsel even became part of this? And that was something that was added with William Livingston, who was a very interesting guy. He goes on to be Andrew Jackson's Secretary of State. He was in Louisiana. He was a legal reformer. He rewrote the civil code for Louisiana, and he wrote a proposed criminal code that was never adopted. The requirements of the warning, including the warning about the right to counsel, which for the first time, probably since Joan of Arc, comes up in William Livingston's. Now, Livingston wasn't writing a treatise. Livingston was writing a proposed legal code. And what's interesting is at that time in the 1800s, and this may end up being our story, this shows the shift, right? 1824, William Livingston is this incredibly influential guy who writes a proposed code that then gets adopted in New York, in Massachusetts, in some Midwestern state, I'm thinking Kansas. And then there's a fourth state that adopts the right to counsel, the right to warning of the right to counsel in an interrogation in the 1830s because of Livingston. Livingston almost shows us the end of the treatise as the law creator itself, because now everything's becoming codified. Livingston writes a proposed code that people embrace. Prior to that, Dickinson writes a treatise that everyone follows. Now it's the statutes that give procedure, not the treatises. And I think Livingston might be the turning point for the beginning of the end of the treatise as itself law.
This is amazing. This is amazing for what we are writing. I have to see you.
Absolutely.
Wow. This is amazing. So please, faculty members of Duquesne, please come. We are going to discover things about your research that is going to hopefully to propel and help others. So thank you so very much. We are going to continue. And what are the main ideas behind your scholarship? I think we discussed
We
that.
kind of discussed that. Yeah, it all comes back to policing in some way. I don't know why it does. I think it's because like early on in my career, I became really good at and enjoyed Fourth Amendment litigation, and so I kind of like came to I had a knack for understanding the rules that regulated police, and there's almost a chess-like quality to the intricacy of the rules that regulate police under the Fourth Amendment, particularly, and to a lesser extent under the Fifth for interrogations. And I came to really like those rules, and that's what I started writing about early on. So that's kind of, in some ways, informed the rest of my career.
I think it's wonderful. And I want to commend you for that because it's so important in a democracy to follow the rules, especially when it comes to policing. So thank you.
Sure.
What does it add to the existing body of literature
Yeah.
in this field?
Yeah, and I always get this question with history. It's like, so why? Who cares, right? And people are usually polite about it, although not always. They said, so yes, so what? There were times I've gotten so what at the end of this. And so I think it's actually really quite important to know where our rules come from, because it's the question is, do we accept precedent on its face, or do we ask questions about context that may in fact be different? And so, one of the things I hope really happens with my book is that, and this going back to the history of the prohibition stuff, is I hope people ask the question, why are we regulating the police the way we are? And if the answer is because this seemed like a good rule in the 1920s, I'm not sure that's a good enough answer. So, as a defense lawyer, the exclusionary rule was something that I benefited from greatly. And I still, actually, when I was driving in today, I thought about the fact that we were going to do this sit down. And I thought about how excited I was as a young lawyer that I was going to get to have a search thrown out. I was going to get to stick it to the cops. It's like, here's, I'm going to get to show that they did something wrong. And you need people who are litigating to care about the outcome and to want that. But I'm not sure that that's actually the best way to regulate society, at least if what we're asking is, at what cost do we get to this particular system of regulation? And what's interesting to me is that during Prohibition that I write about, all these states start adopting the exclusionary rule. It's not a federal requirement. It's under federal. If you're in a federal court, there's the exclusionary rule that kicks out evidence that's unlawfully obtained. If you're in federal court, that applies. But the federal courts haven't required state courts to do it, though during Prohibition, about half of them choose to do so because people are worried about liquor searches. Prior to Prohibition, no state court is following the federal rule on the exclusionary rule. Okay, that's the 1920s, early 1930s. You flash forward to the 1960s, late 1950s. What's going on in society that's particularly troubling? It's not illegal searches and seizures like it was in the 20s. Actually, legal searches and seizures were a problem in the 20s because people were drinking alcohol and they didn't want to be bothered while they were drinking alcohol. There was a really cool room. If you've ever been to Club 21 in New York, which is now closed, there's down in the basement. There is a room where they would hide the prohibition, the drinkers during Prohibition, and they had a particular booth for Mayor Jimmy Walker, who was called the nightclub mayor in 1925 of the city of New York. I think he served 2-year terms at that point, so he's very briefly the mayor. And they showed Jimmy Walker's booth, and it like vault-sized wall. They could close it up. You couldn't tell if there was anyone behind the wall. It's really neat. I think 21 is now closed, but yeah, when the rules that people came up with because they didn't want you searching legally or illegally for alcohol, then find their way into the way that the U.S. Supreme Court is regulating police generally. Now, I'm not saying it's a bad thing to have a rule that deters unlawful searches and seizures, but at what cost? So, 1961, the U.S. Supreme Court decides Mapp versus Ohio, which now requires all the states to exclude unlawfully obtained evidence. What's going on in late 50s, early 60s? It's police brutality. That's the concern. Police brutality has always been with us, but there was a spike in concern about search and seizure in the 20s because of Prohibition. We never have seen a generic concern about search and seizure from like top to bottom of society about that issue since Prohibition. But during the 20s, you could pick up any newspaper and read things that look like Fourth Amendment treatises because all the op-eds were about when can you search, when can you seize. Flash forward to the 60s, the U.S. Supreme Court's very concerned about police-citizen relations, particularly in minority communities, because with the civil rights movement, with general societal unrest, with a whole bunch of folks moving from the South into northern cities for jobs, there's all this racial tension. There's all these like policing issues that come up. There are the freedom riders. There are all these things that come up with citizens and police, particularly Black citizens and police. You get during the 1960s, you're going to get the creation of the Black Panther movement because of concerns of racially motivated police brutality in Oakland, California. The city of Newark is going to go up in flames. Watts is going to go up in flames. Cleveland goes up in flames, absolutely because of these concerns about police-citizen interactions. So what does the Supreme Court do in 1961 to curb police excesses at a time when the country is literally about to go up in smoke because of police-citizen interactions? They create a rule that says if the police unlawfully search you, they can't use the evidence. Searches and seizures weren't what was causing these riots, or weren't what was about to cause these riots. It was physical violence. So what the Supreme Court does is in 1961, it spends its political capital to curb police in a way that doesn't actually address the biggest issue of the 60s. So I'm all in favor of having a way to curb unlawful searches and seizures. Great. But if the rule that you nationalize prevents the court, in fact, we know later it did prevent the court from going further on certain issues. For instance, lineups. The court, when they got to lineups, said, look, we could throw out some of these lineups, but we've already seen from Map versus Ohio, people don't like throwing out valuable evidence. Well, the lineups that were being asked to be thrown out were potentially suggestive and lead to false convictions. And then I think it curbed regulation that would have looked at ways to curb or would have looked at ways to address police violence itself. There was an alternative to the exclusionary rule, injunctions, that would have enjoined all police officers from violating the Fourth Amendment and therefore given every trial judge in America the power to sanction searches or violence with either fines or jail time. And that would have addressed both. The fact that the Supreme Court chose this prohibition era remedy of exclusion of unlawfully obtained evidence meant they only hit the 1920s issue that was only marginally an issue in the 60s. If they had chosen the other route that wasn't as thoroughly vetted, wasn't as thoroughly tested, of giving trial courts the power to sanction police excesses, whether search or violence, then we would have had a rule that was tailored to the problems of the 60s, not the 20s. And that's why I think it's important to study history, because we can ask the question, why? And if we know that precedent is somehow tied to something idiosyncratic like prohibition, then maybe we can say, okay, folks, let's not hang on to this merely because it's precedent. Let's ask whether that precedent is something literally linked to the past, and there's a better way to move forward.
Wow, this is amazing.
Okay.
I just love it. I look forward to read everything that you're going to produce.
And that's all in the prohibition book I've already written.
That's wonderful. And you are going to further develop it.
Right now I'm not. Right now what I'm working on is there's the Joan of Arc story, and the Joan of Arc story is kind of a side story for me. My big effort right now is the stuff that we're going to put into the police cars for the device I'm looking to build to put into police cars.
Because that will take care of what you said of the violence.
Well, actually, this actually, because I mean, this what we're looking at here really is the search and seizure issue. Yeah. Even though I say it's a lesser issue, it is still an issue, but one that we can actually immediately rectify or immediately address in a much better way. We can go leaps and bounds forward on search and seizure and drug interdiction stops. And those aren't the worst violations, but those are things that if you are falsely searched, and this happens disproportionately to people in poor communities, then that itself undermines the credibility of police in those communities. So what I have found as I've gotten into working with, with artificial intelligence, machine learning and such, is that we actually believe that we can make a huge step forward in that area so that the legal regulation, like the legal need to exclude evidence, will be much rarer because we think we can dramatically reduce the number of unlawful searches and detentions for drug interdiction.
And also violence, because a lot of shootings happen after perceived illegal search.
Yes.
So that would be wonderful.
Yes, and then there will be like downstream effects. Hope if this actually works and we're able to deploy it in any kind of big scale. The hope is that this will just enhance the credibility of police and make people less afraid of them in a small way.
Yes, that would be wonderful. And the next question, how do you think that you being so successful publishing scholarship has affected your teaching?
So it's interesting. Success in publishing, I often envy people who've gotten much better placements than I have. So I don't actually describe myself as a successful scholar. When people say I'm a prolific scholar, I'm like, okay, yeah, I'll put a lot out there. I'm very envious of people who have cracked into regular publishing in the top 10 law reviews, that kind of thing. Now, I've hit those a couple times, but only in really short pieces. My best works are in lower ranked journals. If you can almost look at my anything you see from me that's published in a top 10 journal, it's going to be short and not say that much. My best stuff is actually in mid-range journals, it seems. So, but how has the work I've done affected my teaching? Try to integrate it. And one of the frequent complaints I got about my criminal procedure class was that he's not actually teaching us the law. He's teaching us what he thinks history is. Well, no, actually teaching what actually history really is, but what history really is. But it does shape the way I go back and explain this, because I feel like you can organize the story of the origins of criminal procedure around the history, and I do that, though that hasn't been a particularly popular way historically. I've found from the student's perspective. The computer science stuff obviously radically changed my teaching. I was not teaching a class on coding before I started this work, and I started working on this, and we were working with a technology firm, and we got tired of not knowing what was going on under the hood. So, my research assistant, Morgan Graves, now my research partner, who's getting his PhD in computer science, we realized we needed to know this stuff. So we started taking classes online. He gets into a PhD program at Pitt. I'm working toward a master's in computer science at Georgia Tech. And we decided to teach a class on programming to lawyers. That's what we're doing this semester.
That's wonderful, because one of our DCLI faculty member, Katie, is interested in creating a class upon technology and research to add to our curricular offerings.
Wonderful.
Yes, and there is a conference coming up, and she may go there, and we want to see that. I think it's important for attorneys to know more about technology.
No question about it. And we're doing something very different than what you're typically seeing with this. A lot of sort of technology and law interactions, either a regulation about the technology, or it's looking at particular uses of apps, whether that's e-discovery or how do you use certain databases and such. We really are showing folks from the start, step one, print hello world. And now let's build up from there. How do you get a computer to do all these things? And the reason we're doing it is, I think maybe a couple people will end up becoming like Morgan, that they'll go and get their PhDs and start building their own apps themselves. But we also think that there are people who, when they're talking to a computer scientist and the computer scientist is saying, this is how this works, you won't know all the twists and turns from my little class, but you won't be lost.
Exactly.
When the computer scientist starts, well, we want to put this in that data structure, and we got to get this out of there, blah, blah, blah. We don't want, because people now, most lawyers have no background in this, and it just sort of sails over their heads, and they feel intimidated. They don't know how to interface with computer scientists. Everyone who's taken this class will be able to do that. And from the projects that they're building in this class. And you're all invited to come the last 3 days of our class. It's Monday and Wednesday, and it's the last 3 days of class. People are presenting their projects.
Please let us know. We will advertise that we will come.
Absolutely.
It'll be wonderful.
Absolutely. We will. So you'll see from their projects that these folks are actually very capable of building things from the ground up. And if they continue in this, this could be a whole new employment path. And, doing this sort of thing has real potential for access to justice. Morgan and I are working with Kate Norton in the clinic right now on an app that will help folks who are doing family law appeals make sure that they haven't defaulted because they left something out of their brief.
This is wonderful. Rather than be scared by technology, embracing.
Absolutely.
This is really tremendous, and I commend your work, and I think it's great in terms of opportunities. Creating jobs. I've been working. I don't have the manpower on a particular website that shows, for example, in West Virginia, on flooding. Apparently, it's the worst state in terms of flooding, but because the density of the population is not as much as in Florida, you don't hear anything being talked about in West Virginia. However, there's a lot of money, federal money, going in West Virginia in particular instances, and
because of Joe Manchin.
Exactly. And I would like the students involved in this website to follow up the money. So this was given to this particular municipality or this particular agency. What exactly have you done with it?
Right.
And that would be very easy with something interactive. So the more you know about coding, the more you can create job opportunities.
Yes, absolutely. And the more you know about coding, the more you can just sort of think through problems.
Exactly.
One of the really nice things that somebody said to me midway through the class was that she said she thought that she was a better writer because of the class, because this forced her to think methodically, and it forced her to think about whether she'd left out an important step.
That's excellent. So this is so wonderful talking to you, Wes.
No, thank you.
So we are continuing forward with the 8th question. What are you working on right now?
All the above.
You told us.
All the above. Right.
So that is wonderful. What would you like to work on next after you're done?
So this actually reminds me of a question. I was interviewing for a job the week I finished my dissertation. I turned it on Thursday or Wednesday. My interview was Friday.
Your dissertation was on?
Oh, my dissertation was on the history of the New York police from 1850 to 1940. And so I turned it, I mailed it off on Wednesday. And then on Friday I had this interview. And so they were asking me about the dissertation and what I studied at school or teaching or whatever they asked for in an interview. And then one guy on the faculty who was asking me these questions said, one of the people was asking questions, said, so what's next? I said, I'm really thinking about a nap. As I'm finishing a dissertation, I literally have no thought about what's coming next. So I kind of feel like that, like when I get a chance, a nap really is in order. But
I think it may be a while.
Yeah, it might be a while. Yeah. But so where do we really think all of this is heading? We're starting to create partnerships with police departments. And so, when this actually, we're just pushing this thing out the door. We're trying to get it to where we can deploy it. We now have a police department, I don't want to name them on tape, that is ready to accept it when we're ready to deploy it.
This is fantastic.
And it's a major police department.
It's fantastic. Yeah. It's extraordinary.
Yeah. I kind of think so. Thank you.
Oh, I love it. No, I think napping would be a little while from now.
Yeah. So anyway, but beyond my actual project itself, I'm working toward my master's in computer science. So I've got to finish my Java classes. I've got to do all these other things, data structures. I've got to take all these various classes. It's like all of that sort of on the horizon, but that's all in the works right now.
When I was in the city, I used to participate to Girls Can Code. There is this movement that brings people interested in taking classes for free, and corporations, allow a particular space to be used for this particular issue and so forth. and I was very much taken by Python. I think
that's what we use. Yeah.
Exactly. I think if you are a researcher of any caliber, you need at least to be familiar and to understand how it works, because while we are still a long way from artificial intelligence, learning machines are here with us to stay.
Oh, yes.
We know about
absolutely
how they work.
Absolutely.
So I would like to go and say that your scholarship, I think, makes you a more interesting teacher. Even if you didn't want to say that, it sounds to me that you are more focused. You have interests that otherwise, if you didn't do the research for writing, maybe you would not have that. And when we teach, I think people want to see something like authenticity in addition to knowledge.
I think there. I actually though I think scholarship.
That was a compliment.
Oh no! I took it as such. I think scholarship is a two-edged sword with regard to teaching. On the one hand, it gives you credibility. On the other hand, it gives you a whole bunch of details that you're now comfortable with that people who are learning it for the first time won't be. So there was a colleague of mine who really cared about a particular issue at the school where I used to teach. And when I would listen to him talk about this issue, he was so passionate about it, it was too much. Then I listened to him talk about something he didn't care as much about. I'm like, man, that guy's a hell of a lawyer. Because when he didn't care so much and was approaching it just methodically, not in a way that was overwhelming you with like all of the story, but there was like very methodically checking the boxes. It's interesting. One year I taught professional responsibility for the first time. I got no background in it. I don't write. I mean, I get it, like the ethical don't lie. I understand. But like I didn't have any background in, like no real depth in professional responsibility. I took it, so basically I took the slides someone had offered me from the year before. I learned them, I presented them, very bare bones. One of the best teaching reviews I've ever got. And I think I actually understand this. It is a balance. Like when you know something because you've gone into the weeds of it. If someone for the first time is trying to figure out what the exclusionary rule is, you don't need to say, as I often have, so I discovered the origin of this thing in a basement in Portland, Maine, where there was this guy, Neil Dow, who was trying to create a prohibition law in Maine. And there was no way the governor, John Dana, was going to go along with it unless he came up with a way to moderate it. So the thing that he and this guy, Ed Fox, who's a federal judge, who did, they created this thing that's now our current law. If you're trying to figure out what the hell the exclusionary rule is, that's too much. If you already kind of know, well, that might actually be kind of fun. I can show you all the pictures of the houses and show you the debate in the Maine legislature in the 1850s. That's all kind of cool. But I kind of feel like one of the problems, at least I've had in teaching things that I've done a lot of research on, is sometimes I think the students could end up feeling like that they're drinking from a fire hose. And that's actually been one of the interesting things for coding for me. I'm kind of learning it as I'm teaching it. I mean, I started learning this stuff 2 years ago, and I'm now teaching a class on it. And, knock on wood, it seems to be going reasonably well, at least based on the projects that folks are going to be handing in. And so, I think part of knowing a lot about something, it absolutely gives you the credibility. The answer you give is going to be correct. But all of the caveats and all of the context that you provide, because you're now able to do that, can actually be distracting from.
So it's just one element of being an excellent teacher.
Right.
But I think it's a crucial element.
Yeah, I like to think so.
Yes, it is a crucial element. I like to think that too. So moving along. So I think we've reached our 10th question.
Okay.
What would you like to share with us here as a final thought?
Oh.
And this is recorded.
Yeah, I know. I don't know that I have any grand pronouncements. I'd like to think that I don't have a final thought. Jefferson, when he designed the lawn at UVA, didn't want to close in the back end of it. So like there was the rotunda, and then there was this ring of buildings rectangular buildings that went out. He very intentionally said, I don't want I want that to be open-ended, because I want the idea of the metaphor of learning to be that we don't stop with anything, that like it keeps developing. So I like to think that I don't have any final thoughts based on that we'll continue to evolve. Now, then the sad thing is that there was a rotunda fire in 1895, and then there was an architecture firm, a very famous firm that built Penn Station, built the Boston Public Library, McKinney and White. They came in and they rebuilt the rotunda, and it was Stanford White, one of the more flamboyant members of this group, that he had a better vision than Jefferson for the lawn, and he convinced UVA to put a beautiful building at the end of the lawn, and so it is now closed up. But I like the Jeffersonian metaphor so much of it might not be as pretty. This talk might not be as pretty. The lawn actually wouldn't have been as pretty if they hadn't put Cabot Hall at the end of it. But the metaphor is, I gave you a whole bunch of stuff. I kind of hope we all start to keep developing in what we know. And I hope I don't have a punctuation mark to the end of this talk. Yeah.
Thank you so very much. And we're going to applaud you. We are looking forward in November. We'll have Professor Rona Kitchen here with us. And hopefully this will be something that we embrace here at Duquesne Klein. And we're going to have these discussions with our faculty members.
Well, thank you very much.